Scott's name wasn't on there. I was actually very surprised because he's been doing work with us on a lot of good issues. And I sent back to the intern, I said, is this current as of today? And there's this great website for those of you who like sort of political stuff. It's Library of Congress it's called Thomas, after Thomas Jefferson. If you go onto Thomas, you can punch in any bill and it will tell you the status, it will tell you the legislation, pulls up the language, it will tell you major congressional action and who the sponsors and co-sponsors are. And as of today on Thomas, Bobby Scott wasn't listed. And again, I was really surprised when I saw that. I'm not sure what's going on. We would expect him to be a co-sponsor, but certainly if he's your rep, it doesn't hurt to give him a call.
A follow-up question and then another independent question. Can you think of any maybe other issues in the bill that would be keeping him from signing on?
No, I mean, it just may be a function of timing. I know a lot of them, they're very busy, and it has to do with when their staffers can brief them on an issue. Oftentimes, they may not pay attention to it until it's coming up for a hearing. This has not yet been scheduled for a vote, so it may just be that he hasn't had time to pay attention to it. But I'll tell you, there's nothing that gets some members' attention like a few fax phone calls or a visit to the district office. So again, I certainly don't want to say we expect him to not be in favor, but he's a friend, he's worked with us. We would anticipate that he would be, but he may need to know that now is the time. And as far as whether there's anything in, no, I really can't think of anything in it. They're both very mainstream civil libertarian bills. Like I said, it ends indefinite detention, it stops tortured evidence, it restores the right of habeas, and it ensures that government officials who've been involved in torture, not just the privates, I mean, as we all know, privates are doing what they're told, but government officials who've written policy memos, for example, maybe at John Yoo, those officials can be held accountable too. And then you have one follow-up, then go to another.
Yes, sorry to hold you so long. This ruling today in the Fourth Circuit, just a question about possible implications. So it looks like defense counsel are going to have access to evidence now.
Well, okay, so the one problem is there was a decision about 6 weeks ago that where an appellate circuit denied the right of habeas. And what they did is, it's actually a fascinating decision. It goes through the history of habeas corpus. As you know, it goes back to the Magna Carta, 1215, where the English lawyers got together and said, you know, we want to limit the king's right to just put somebody in prison. And as you know, our law in the United States came from English common law. So we look back to English common law on occasion that evolved over the centuries to determine what our rights are. And what they did is they went through an analysis of the idea of writ. And because it has to do with issues of jurisdiction, are there any lawyers here? Okay, there's this great case that every lawyer learns. It's the first one. It's the idea of jurisdiction. It's one thing to have a law, but it's another thing to be able to impose the power, to impose jurisdiction. So what they did is they said, really, the idea of writ only applies when you're in